Let's see. Hi everyone, we're a few minutes early here. We're just getting Aaron to join us and we will be starting the live shortly if you bear with us. There we go, there's Aaron.
Hello?
You hear me?
Looking, sorry.
It is loud.
Loud? Loud?
Yeah, there's a lot of noise.
Let me do headphones for you.
All right.
No noise.
Well, welcome to the Shapiro Law Firm Presents Facebook Live event. Today we're doing a Q&A discussion on inadmissibilities and extreme hardship waivers, which is a very large, complicated topic, and we're going to get through as much as we can. And if you have questions, I encourage you to reach out to us and ask. You can ask us live. We got one question beforehand. We'll get to that in a little. Let me pull it up on my computer as well. So we'll wait a few more minutes for people to join at 9 o'clock, because that's when we're planning to get started. While we wait, we'll give you a little information about us. We're both attorneys at the Shapiro Law Firm. Aaron is my brother-in-law, married to my sister. We practice immigration law, criminal, family, and we've been doing
Pretty much it.
And some civil litigation too. Aaron's phone is having trouble stabilizing.
Well, I just put it down. I was holding it.
Okay. So yeah, we'll just give people a few more minutes. I don't want to give away all the good stuff before 9 o'clock. And let me just get into, oh, there I am. How do I get to my live studio? There we go.
I asked something about EB3.
Hi, everyone.
What's your EB3 question?
What?
Someone had an EB3 question. We're not really doing EB3s.
EB3 question.
Just email me the EB3 question.
Yeah.
Is that okay? I'll put my email here.
Yeah, today we're gonna focus on inadmissibilities and some of the waivers that are available. I guess we'll just get started. There's a bunch of people on, and you can also rewind, rewatch if you've missed anything. So welcome again. Thank you for joining us. We hope you'll find this informative. So the first question really is, what is an inadmissibility? And the easiest way to explain it is, if you're not a U.S. citizen, whenever you want to come to this country, you have, at the border, you have to show your entry document, whether it be a visa waiver, green card, and you have to be inspected and admitted and allowed into the country. An inadmissibility is something that will make you ineligible for certain immigration benefits. It could be anything from a non-immigrant visa to adjustment of status or a green card. Basically, it's something that creates a problem for you. And
let's start, before we go any further, let's just quickly define what an entry is. So an alien arrives at a port of entry. You present yourself for inspection, and you become an applicant for admission. Okay, that's at the airport, at the terminal, whatever. Through the inspection process, an immigration officer will then determine an alien's admissibility and whether or not that person can enter the United States. So that's the process. You come to the port of entry, you present yourself for inspection, you become an applicant for admission at that point, and then the officer will decide if you're admissible.
Correct. And sometimes people get turned away. Denied
Rendered
admission,
inadmissible.
they
Right.
would be inadmissible. Right. And this is not somebody who crosses the border illegally. That is called an entry without inspection or an EWI. We'll get to that in a little bit.
Because the person has not arrived at a port of entry, presented him or herself for inspection, and is an applicant for admission. It really sounds simple and silly maybe to repeat those things, but it's super important because that's the biggest problems in immigration.
Right.
Pretty much.
And you can be subject to multiple grounds of inadmissibilities. We're going to talk about the most common ones today. And they can, so like I said, they can affect your ability to get everything from a visitor visa to a green card. And they can put you into removal proceedings as well. So the first thing that we want to talk about is called a FOIA, or it stands for Freedom of Information Act request. Now, the reason we're bringing that up is that you can file a FOIA and get every document, your entire immigration history from USCIS. And what that does is that tells you everything that's happened. Aaron, how many times has a client come in and told us that they weren't removed from the country or they entered with a visa and then we order their FOIA and what happens?
Yeah, we find, it's not exactly what the person told us.
Sometimes it's intentional, sometimes it's not. Immigration
Yeah.
is really complicated. So if there is any doubt about your immigration past, we recommend the first step.
Yeah, we need to pretty much, I think it's a good idea for everybody who has an immigration history to just file one of these. It's a good way to start a case for us too, so we know where everybody's at.
It does take a few months, but why it's so important is that we may go through your file and realize you're not admissible, you have a permanent bar. If you file for the U.S. government is going to try to deport you. And on the flip side, we may think there's nothing. We've had remember that lady with the temporary residence? We thought there was nothing we could do for her. But we're like, let's get the FOIA. She was like, no, I've had this and that before. We did it, and we found out we could, and now she has a green card. So it can work both ways. The important
and
thing,
245I.
Right. The important thing is to have accurate information about your past. And, like I said, it is complicated. So giving us the ability to review it all really helps. Somebody sent a question by email. I'll take a look at well, Aaron, take a look at your email too. I'm not sure whose email.
Oh, the EB3 guy?
I don't see one.
I don't see one either.
Pankaj. All right, while you look, I'll keep going. If you're just joining us, welcome. We're talking about inadmissibility and waivers today.
Maybe check that
now,
the info email.
Oh, not yeah. I have that one. I didn't see it.
Check your email. We don't see it.
Hank, you can also directly message us, I believe. So, where are we? So within admissibilities, there are some exceptions as well as waivers. So I'll give you a really easy example of what an exception would be. If you entered the country with a B2 visitor visa, and then you didn't leave when you were supposed to, and then you married a U.S. citizen, and now you're applying for a green card. If your spouse is a U.S. citizen, even though you have an unlawful presence, which is an inadmissibility, the immigration law says there's an exception for immediate relatives, which is defined as a spouse of a U.S. citizen, a parent of a U.S. citizen, just spouse or parent, right? Yeah. And so even though you stayed past the time you're supposed to, even if it was 10 years, you will not have any problems. You won't need any waivers. that's an example of an exception. We have a question. Do deportation before 18 count? Yes. Your immigration history before you turn 18 does count. However, even if you're in the country illegally before you turn 18, you don't start through unlawful presence until the day you turn 18. What that means, we've actually had this situation with clients before where someone had DACA. She got DACA before she turned 18. Her father filed for her, and because she had DACA and didn't get unlawful status, she still had to leave the country to get her green card and come back because she wasn't an immediate relative petition. But she did. She didn't need a waiver. So if she didn't have DACA from the time she was under the age of 18, then she would be facing an inadmissibility of unlawful presence and would have had to file a waiver. So it's very important that you know exactly what the situation is in order to properly advise you on if a waiver is needed or not. And we'll get to the waivers in a minute about what's required, but we're going to talk about some of the immigration violations first that will cause someone to be inadmissible. We've already touched on some of this. So we talked about unlawful presence. Unlawful presence would be anyone who stays past the time they're supposed to if they came as a visitor. It can also be someone who violates the terms and conditions of their visa. So a good example is someone who enters as an F1 student. Usually F1 students, they're not given a specific date they have to leave. They're given a D/S, which means duration of status. But if you stop going to school full time, you're in violation of your visa, and that creates an inadmissibility. So any violations, and that includes any crimes, and if we'll get to some of the criminal inadmissibilities a little bit later.
Yeah, not every crime renders you inadmissible.
There's exceptions
and
as well.
it gets really complicated. And if you have a crime, normally we need to talk to you personally.
Correct.
With some real details.
So you have the unlawful presence, and you also have, we mentioned earlier, someone who crosses the border illegally. It's known as an entry without inspection or an EWI. So this is a person that did not present themselves at a port of entry with an appropriate document to enter the country, even if the document was not in your own name. That's a fraud and misrepresentation, which is another ground of inadmissibility. But for an EWI, it's somebody who just kind of walks in. Another ground.
Now, to keep note, there is, for somebody who did come with someone else's passport or maybe someone else's, and visa, obviously, it's all in the same passport. If we can show the entry somehow, we apply for an adjustment with the waiver. So you can actually do it when you're in the United States. You don't have to leave. It's a huge difference.
Well, we'll get to that.
Than someone who does an EWI.
I was just about to touch on the difference.
Sorry, I don't want to interrupt.
No, you're good. I know people are probably, that's a big question people ask us.
Right, that's what I figured,
yeah. To any inadmissibility ground if they have to leave the U.S. to get a green card. And if they do, how long? So that was where a significant difference comes in between somebody who says, look, I entered 20 years ago. I had a visa, but I don't have it anymore. A FOIA may help, but if it's for some reason not in the FOIA and we can't prove your entry, then you're in the situation. And instead of the 601 waiver, it's a 601A waiver. And with that waiver, you have to leave the U.S. for a period of time. The good news is, as opposed to when was it that they passed this in like 2012 or something? Aaron's looks like he's having technical difficulties, but you get to apply while you're still in the U.S. and then you can apply for the waiver, wait for it to get approved, and you don't have to actually leave the U.S. until it's approved. So essentially, you're only outside the U.S. for a couple of weeks, which is nice. Whereas if you were able to show you entered, even if you entered with someone else's visa, which is a lot harder to do these days. Well, let me re-invite Aaron. He says he can. I can't invite you yet, Aaron. Sorry, guys. Give us 1 second. I can add Jessica. Let's see how that works. All right. Well, while that's time to add Jessica, which is hopefully Aaron, we'll keep going. So another common immigration violation is working without authorization. 1 second, guys. Aaron, you can send me a request to join. So try logging out and logging back in. Oh, I'll try adding Jessica again. Okay. All right. Sorry, everybody. Let's keep going. So working without authorization, another big one.
Sorry. Oh, wait. Shit.
Okay. But it's also another ground where it's another one where there's an exception. And if you're getting a green card based on your relationship to someone who's considered an immediate relative, so again, a spouse or a parent of a U.S. citizen, then the fact that you worked without authorization is not an issue. We lost Aaron, and I'll try one more time. Okay. So, what does a waiver do? Well, a waiver basically excuses the ground of inadmissibility.
I'm back. Sorry about that.
No worries. Now, like we said, there are certain grounds that cannot be waived, and it's important that you file the correct waiver. We talked about 2 main types of waivers, the 601 and the 601A. They have very similar requirements, but the 601 is more of a general waiver. So it will waive all sorts of grounds of inadmissibility. Aaron, there's like some feedback. I hear myself feeding back.
I'm sorry. I apologize, everybody. I have 2 phones and one. I couldn't figure out which camera was looking at me. It's a complicated problem if you think about it.
All right. So you have the 2 types of waivers. The 601A only waives the illegal entry or unlawful presence. And if you have 2 grounds of inadmissibility, let's say you have committed a crime that subjects you to a ground of inadmissibility and you're an E-wait, you can't do a 601A. You have to do a 601. But that's another story because that's even more complicated. Aaron, can you put your headphones back on?
No.
Because it's or mute it, I guess. I don't know.
The thing is,
it's pretty.
Hold on.
Pretty loud.
Is that working?
I have to talk. Yeah, you see, I can hear myself. It's pretty bad. Yeah, it's a lot of disturbances. Yeah.
Back to my
Yeah.
phone.
Yeah, just call me, Aaron. That might be better. Because it's not, yeah. Sorry everyone about that. This is Facebook Live thing. It's not, doesn't like co-hosts. Okay, so moving along. Now, there are some situations where someone who's entered illegally can actually end up getting a lawful entry, and that's with advanced parole. It's very rare these days, but because they don't, DACA advanced parole is one way we did it, TPS advanced parole is another way. But basically, if you enter, you have to assume if you entered without inspection that you're going to have to leave and come back in. Another issue that can arise if you're in removal proceedings, you cannot now these days file for a 601A. That is because the judge will not terminate your case. And if you leave the U.S. while you're in removal proceedings, you're deporting yourself. And that's another ground of inadmissibility. And you kind of compound your problems. So one thing that gets confusing with the immigration law is that anyone who's here in violation of their visa or overstays their visa and accrues unlawful presence, they don't trigger the bar to re-enter the U.S. until they leave. So you could be here for 20 years illegally, but once you leave the U.S., that's when you trigger the bar, and that's when your problems arise. So that's why the nice thing with the 601A waiver, you get it approved before you leave. You don't trigger the bar, and you have the waiver approved. So there's a lot more peace of mind. Whereas the 601, you actually have an entry already, and you don't need to leave. It's okay if you're in removal proceedings, depending on what the issue is. As I said, it covers a whole host of inadmissibilities, including criminal grounds, the public charge ground. We're not going to touch on public charge today. That will be for another live session. Health grounds, so people with communicable diseases such as HIV can be actually HIV I don't think is a specific ground anymore, but diseases like that can't be cured. Hold on one second. Aaron says he figured it out. Invite him again. All right, let's try this again, Aaron. Let's hope. Oh, I see Aaron. Okay. All right. Looks hopefully it. Okay, there we go. Hopefully this is better. So let's start with the 601A. What's the procedure? Well, first, you have to have a requisite relationship to an immediate relative. So either a lawful permanent resident spouse, U.S. citizen spouse, lawful permanent resident parent, U.S. citizen parent. One of those relationships, and that person has to petition for you. They file the alien relative petition, and it gets approved. Your case then goes to the National Visa Center. You pay the immigrant visa processing fee. And then you file the 601A waiver. That's going to take 6 months, a year. In COVID times, probably
more than that.
Probably double that. Once it's approved, then you finish up submitting your affidavit of support with the National Visa Center, the civil documents, the immigrant visa application, and then you're going to get a notice, hey, we have everything, time for your interview. They're going to schedule your interview abroad, and then you're going to leave the country. You're going to get a medical exam, you're going to go to your visa interview. All goes well, you pass the interview, you're going to come back into the country on an immigrant visa this time, and then they're going to mail you your green card within, I think, 60 days of your entry. That's how the 601A works. The requirements for 601A are you have to first, to file it, be physically present in the U.S. So yes, that means even if you're here illegally, you have to be physically present here. We have a question. I'm waiting for 601A to be approved any day. If embassy opens, I get appointment this year. My country is for by president. No new green cards affect me.
What?
Oh, he's talking about the executive order, proclamation, or whatever about.
Who knows? Don't even waste your time thinking about it.
No.
That's after the election.
No. I don't think that applies to. It doesn't apply to immediate relatives. It only applies to family preference category. So if you're married to a U.S. citizen,
No,
you can if you're in removal because they will not.
Because you're here.
Your case has to be terminated. You can ask the judge.
If you leave, you're gonna. If you're gonna leave, you're gonna remove yourself.
Yeah, you remove
basically.
yourself, and now you have to file another waiver on top of the waiver, and it's really.
Yeah, if they'll agree to terminate, they won't. They don't do it like that.
No, they used to. Maybe with a new president and a new administration, they will again. They did in the past, but yeah, now if you're in that situation where you don't.
You're gonna have to ask the judge.
Entry,
I mean.
Yeah, you
You're
can
gonna have
ask
to make
the
a
judge.
motion.
But there's a better chance. Hopefully, you have 10 years physical presence and can do a cancellation or removal, which is which we're not going to talk about today. But in terms of showing an extreme hardship, you actually have to show extreme and unusual hardship with that. It's even harder. But getting back to 601A requirements, you have to be age 17 or older. You have to have an approved immigrant visa, so that's the alien relative petition. You have to have your case pending with the Department of State and paid the processing fee. And you have to not be inadmissible for any other reason. And finally, most importantly, you have to have an extreme hardship to a qualifying relative. And for 601A purposes, a qualifying relative is a U.S. citizen or lawful permanent resident, spouse, or parent. Now we're going to get to what an extreme hardship is shortly.
What that means that's really important for everybody, and they always ask 100 times every day. Not really. We're not that popular. But a lot of people try to base a hardship on the children, and you can't directly base it on the children because it's not your spouse or parent.
They're not
so
a qualifying relative. Yes.
Right. So the hardship has to only be considered through how it would impact the spouse or parent, qualifying relative.
Correct. So there are ways to do it. I mean, it's not a slam dunk. But we'll talk about extreme hardship in a minute. Let's talk about the 601 first, some of the grounds there. Because in both types of waivers, you have to show an extreme hardship to a qualifying relative. So it's the same discussion. So let's talk about the types of other grounds of inadmissibility to give you an idea that if you have one of these issues, you're going to want to talk to an immigration lawyer before you do anything.
Is it an organization or an EAC? What's an EAC?
Yeah. You can apply if you have a pending adjustment of status application or asylum application or something, but you can't just apply based on the approved I-130, unfortunately.
Yeah, you need to have a category upon which to request employment authorization. So the idea is, if you have something where you're here legally and you're pending and kind of waiting through the process, that's when you can get a work permit. If you have a pending asylum case, if you have a pending adjustment application, if you have a pending, if you have a non-immigrant visa, you can work. There's a lot of different things, but you have to have something else going on. An approved petition is not a status.
The only type of petition,
you can file an I-130 for anybody.
Yeah.
Doesn't mean they have status, doesn't mean they're adjustable, which means it doesn't mean they can get a work permit.
Well, there is one petition that you can get one, is a VAWA, so you can get a work permit.
Oh, that's a different case.
Yeah, but that's the only
we're not talking about that today.
So, in terms of waiver grounds, fraud and misrepresentation, we touched on that a little bit. Now, when you talk about the 601 waiver, as I mentioned, that there's all different types of inadmissibility grounds. So depending on what your ground of inadmissibility is, will change what you need to prove. For example, if you have certain criminal grounds, you need to wait a certain amount of time since the offense occurred before you're even eligible to file a waiver. Whereas if it's based on the fraud and misrepresentation, you could have falsely represented something yesterday, and
at the interview, you could do something at the interview, a marriage interview, and you could totally mess yourself up at the interview. I was in an interview this morning, oddly enough, during Corona. I was in an interview this morning in Newark, and it was okay, but it was close to something like that.
Yeah, so the fraud and misrepresentation cover many different things. We mentioned the visa fraud, using someone else's visa or passport. One important note about that: if you ever use someone else's U.S. citizen passport or represent yourself to be a U.S. citizen, forget it. You're done. That is the worst thing you can do in the eyes of the immigration law. There are no exceptions. You're permanently barred.
Here's a tidbit.
Period.
We had a case with a guy who marked citizen on a paper years ago with a healthcare census worker. They were just going around asking people to do a census for health insurance purposes. And the lady who was doing it told the guy that that she was an immigrant, every signature helped and it didn't matter. Many years later, he's in his interview. Turns out somehow immigration had a copy of this.
Yeah.
And Unbelievable stuff. So they
Yeah.
made the false claim allegation. You can't claim to be a U.S. citizen anytime ever. That's the rule of thumb. It's the only thing you can't ever fix, ever.
Oh, that and murder.
Ever.
Murder. Murder.
I had a guy murder.
Murder, torture, and conspiracy to commit murder or torture. Those are like the.
We had a murderer. Couldn't
no
get him out of even jail.
question.
They couldn't even release him, do anything.
Yeah.
He's from Italy.
So yeah, so the ground, and you can apply for multiple grounds at the same time. And you also have to, besides the extreme hardship, which we're almost there, you also have to show that a favorable exercise of discretion is warranted. And what that means is you got to have to be a person of good moral character. If you have, even though you can apply for criminal ground of inadmissibility, if you have a huge rap sheet, if you are like known for being a horrible person, if
Not even a horrible person. We had a guy who had, I think, 8 different arrests for like little tiny nothing cases. It was soliciting the rental of bicycles in Central Park. Remember?
no, he was not. Yeah, but he
That was a few of them.
Yeah.
No, nothing. He had no convictions. He just had arrests. And sometimes he would take a violation, some sort of like, little nothing. And years later, he had no inadmissible, nothing makes him inadmissible. Years later, when he came to us, we did his adjustment. They denied his adjustment because he didn't show that it was in the interest of the country, good moral character, that kind of thing. And he's like a father with a bunch of kids. And if we were in court, we'd probably have no problem getting him adjusted because you have someone intelligent to talk to and deal with. But with USCIS, you can't even get really back at them to talk. And they wouldn't refer him to the judge. So he's still not adjusted. Kid, wife, all that.
Yeah.
No other troubles.
Yeah. So the way what we do here is we have, even though USCIS runs background checks, we have people who get a certificate of good conduct. So you go to the police, give them your fingerprints. They show you have no criminal history. If you belong to a church or synagogue or mosque or any religion, we get a letter from the leader of your religion, however you say it. I'm sorry.
Clergyman.
Clergyman. There we go.
Maybe, I don't know.
Whatever. Point is, we want to show that that's a good thing. We show we want to show also. What was the other big thing with good moral?
You know what I do? I give people a hard time with this because it's our job is a lot easier if people give us more documents than less documents. So I make people sign up for community service, volunteering, all sorts of stuff. The AIDS kitchen place. What was that? I forgot the name of it. It was some sort of place that does cooking food for people who are AIDS patients. Always stick them over there. The place is great. But that helps.
And paying taxes is also a positive factor that we can use. But essentially, what we're
sometimes
part of, yeah, sometimes. But if you don't have to worry about working without authorization.
Yeah, pay your taxes, right? The lawyer says pay taxes.
Still pay your taxes. So when we talk about the favorable exercise of discretion, it is part of even
that's
a
right
argument. And basically, we're talking about a totality of the circumstances approach. And what we mean is that when we submit a 601 or a 601A waiver, there's not one factor ever that USCIS is going to look at and say, we're going to approve this or we're going to deny this. They're going to look at everything. As your lawyer, what we do is we're your storyteller. You give us your facts and we tell them your story based on your facts. So we
help you tell your story.
Yeah, based on what the story of your facts are. We don't make anything up.
We're not writing anybody's story. People ask us all the time. We're not doing it. No.
But the point is that you want to show all the good things that you possibly can and show that and discuss how you don't have bad things. And the place that we start is with your own statement and the statement of your qualifying relative. That is the number one piece of evidence that we submit. And we are really successful when we file these because we take the time to make sure you have all the information in there that USCIS wants to see.
It's the backbone.
Yes, it's the backbone. So what your statement does is it serves as like kind of like the guide for all of your evidence, because we're not making things up here. You're going out and getting these documents, and they're going to back up everything that's in your statement. So if you say, look, my wife is going to be so depressed, she might, she's contemplating suicide if I leave, then you're going to a doctor, to a psychiatrist, and getting a letter to back up that your wife has now been diagnosed with major depressive disorder. So it's your opportunity to tell USCIS why you deserve a waiver, why your family needs you here, and why if you had to leave the country, they cannot leave with you. So there's two aspects of this waiver that's really, really important. If you only talk about one, it's going to get denied. We have a client right now that I was reviewing today to tell them what evidence. Their 601A waiver was denied previously because in the request for evidence, they wanted evidence that the wife couldn't leave with the husband, and they didn't really tell them why she couldn't leave with him, so they denied it. So you have to show that you cannot, your qualifying relative cannot stay here without you, and that your qualifying relative cannot go to your country with you. And not just that they're going to suffer an extreme hardship in both situations. So Aaron, what is an extreme hardship?
An example? Brain cancer surgery. That was a good one.
Well, I was thinking.
We had one that was a bus driver who was going to lose his pension, and he was like 27 years in, and he was so close. Remember that?
I did.
That was one.
Well,
we got a whole bunch of them.
Essentially, though, it is something that goes above.
Oh, you can tell the definition.
Yeah, above and we'll have plenty of examples, but it's something.
I like stories. An
extreme hardship is something that's more than what the average person in your situation is going to suffer from. So, look, anyone who has a family member who might get deported is going to suffer a hardship. I mean, just the loss of having that companionship, right? That's normal. That's average. An extreme hardship is more than that. It's more what the average person. So yeah, you might have a hard time if your spouse isn't here, or your parent isn't here, or your child isn't here, but you have to prove that your time is going to be so hard that it's extreme. And again, the way we do that is by looking at everything, the whole picture. So even in that situation, we had the client talked about with the brain cancer. The client who had the brain cancer was the immigrant, not the U.S. citizen.
The immigrant.
That was a twist that made it difficult because unless you're a VAWA self-petitioner and need a waiver,
they're not that worried about the immigrants.
They don't care about the hardship to you. They only care about the hardship to your qualifying relative. So we had it was still a lot harder, but we were able to show that, look, if she leaves this country, she can't take care of herself. She can't get the medical help she needs. She's probably gonna, not be here for very long. And her husband, their entire family was here. He's the one who owned a business. So we put business records. We put in, obviously, the taxes.
Yeah, and he had people working for him.
Yep, we put in, if you've got...
Show all the loss to the, all that stress and all the responsibilities, remember?
Yeah.
If you lose your business, you still are going to be on the hook for contracts you've signed. Think about that. If you're a business owner, you're going to suffer hard if you got to leave the country, because you don't only have to think about how the hardship is going to impact you if your spouse leaves, but also why you can't leave with your spouse. That's critical. So in that case, we showed she would have brain cancer treatment here, that it wasn't as great over there, but we found that there was treatment available, and that made it a little harder.
Ecuador has a great healthcare system.
Yeah, because it's a lot of expats go there, and it's very good.
But yeah,
we did. We had a few different doctors.
Yeah, our initial thought
in Ecuador.
Was, we're just going to show she can't get the medical treatment, but we have to.
No, this is a great place to be.
You have to submit country conditions. If you're going to say that somebody can't go to this country for any reason, whether it's there's a lot of crime, poverty, bad medical facilities, it doesn't matter. You got to back it up. So we always submit country conditions evidence with it as well, almost like we're doing an asylum case in that sense. So we go to
Yeah.
the department. What?
I said, yeah.
Yeah. So, so yeah, it is. Waivers are just if you're having caught on, they're a lot of work and they're not easy, and you're not going to get it granted if you don't do it correctly. And we see this a lot where they're half of what is needed to be done, and they don't get approved that way. So um, when you're looking at all the factors we've talked about so far, we've talked about medical, we've talked about financial. Now, the financial, one thing we also use is to show that qualifying relative is going to have a debt, like a student loan debt or a mortgage, and that in their country, we put in proof of the average wage in that country to show, look, they may, even if they can get the job in their country, that they have, or in your country, they're not going to be able to pay off this debt that they're now leaving in the U.S. A lot of times, people who are professionals or a trade profession, they have certain certifications and licenses. Those do not transfer to other countries. So
yeah, it's very hard for doctors to move here.
Doctors, lawyers, carpenters.
Lawyers can't move.
If you've been employed by the same employer for a really long time, that's a huge positive factor. So because in your career, you've built a reputation, and you've gotten promotions and raises, and you're going to lose all of that if you leave. But we can't just say it. We have to say it, but then we have to back it up. And that's where these waivers can take a long time to get prepared, because what I always tell people is to be patient, because in reality, you only have one shot to give them all your evidence. You do not want a request for evidence.
We get them.
You get them, but you try to avoid it, because if
It's
you
a pain in the
get a
butt.
request for evidence, it's delaying your case significantly, and it means you didn't do a good enough job the first time around. Now, we've got requests for evidence where
not
at all.
It's not that. It could be anything, but you got to be good. You got to just put as much in as you can.
The goal is to give them everything at once.
Yeah. It's also a lot easier for us.
Yes.
But yeah, you don't want to do this request for evidence or like submitting things in different parts. It's just not a good way to do things.
You want to
make
it as easy as possible to USCIS. Hi, Sherlyn. Thanks for joining. So it takes time, but the way we do it is, client comes in, we have a list of questions we asked about, like, do you have any children? Are they U.S. citizens or permanent residents? Where's your family? Does anybody have any medical conditions? If you have kids, do they have learning disabilities? Any problems in school? We've done it based on behavior problems, that if mom had to leave and dad's at work all day, and the kid's already having behavior problems, and he's in special class or has special attention for that, and is not going to get that back in the other country, that can constitute an extreme hardship. We had
one approved, right? Where there was a family from a Caribbean country, and it was a little girl was here, American citizen, and this is a cancellation case. It's also a hardship. It's a waiver case. Cancellation counts. But she was freaking out about a bug in the office one day, and like really freaking out, really freaking out about a bug, kind of ridiculous. So I spoke to the mom, and then I spoke to a psychiatrist, and then I had her sent over and treated for like a year or two on arachnophobia, and it was a real thing. And we were able to argue in court that the fear was she didn't have control over her motor's response when she would see bugs, so she just would run. It was like really weird. So in a Caribbean country, there's bugs everywhere. And it's very dangerous for little kids to be running off the hook, and they could get hit by cars and die. And the judge they granted it. That was pretty cool.
But we had to prove she was going to the psychiatrist, and we had to prove that there's a lot of bugs.
And it helped her.
You can't assume that USCIS
She's probably over her arachnophobia now.
Yeah. You can't assume USCIS knows anything. You have to show them everything.
Yeah.
So, we ask all these questions, I was going through community ties, another important one. That's what we'll ask about. Do you practice religion? Do you go to to your place of worship regularly? Are you known? Do you do community service? You know, those are all those things. And another incredibly important thing is we can't help you if you're not honest with us. Because if we don't know everything, we can't deal with it. And you have to assume that immigration knows everything. You'd be surprised, especially today with like
Facebook.
Yeah, everything. So
they do check your Facebook before you walk in the door.
Yes, and just to touch back on the FOIA that we spoke about, if you weren't here earlier, the FOIA is the Freedom of Information Act request. Oh, we got a question here.
What if you don't remember who ever said? Ugh.
Ooh.
I think it's an interesting.
Isn't it just a representation to the U.S. government?
I don't think so.
I thought it was.
I'm gonna look it up. No, I think it's even if you say I'm a U.S. citizen jokingly. Let me take a look.
I think it's to gain I'm pretty sure it's to gain a benefit. That's a good question.
Well,
we know
if you say it on an employment document, then it's a problem.
Yeah,
probably.
If it's a private employer,
maybe
not. But if.
But that's what the next question was going to be. Is like,
yeah.
Who's going to know? But one of the questions they ask you on the application is, have you ever falsely claimed? And
in writing.
I suppose.
Yeah.
Yeah, I suppose. If you don't know if you falsely claimed, then you wouldn't say yes necessarily, but it would be something to investigate.
Yeah, I mean that's tough because if it's a private employer, or even I don't even know if it's a government employer, you'd be able to get those records. But I'm pretty.
It's best to call.
What's that?
It's best for him to call.
Yeah.
Or her. Yeah, and don't claim to be a citizen on things.
You never want to do that. That if you missed it earlier, claiming to be a U.S.
I mean, that's probably an extremely illegal thing to do, actually.
Is one of the worst.
I'm wondering what document you would put it on.
If it was on like a W, what are they? W4s to
W9, right?
W9, yeah. That would be a problem. That's a government form. I'm pretty sure it has to be a representation to some type of.
Yeah, but if you tell the employer and then they're relying, if they're relying on that, then.
If you filled out a form that they like the I-9, it's I-9.
I don't think that false claim to citizenship is limited at all. I'm gonna look.
Yeah, take a look. That's a good.
And don't write that on the internet.
Hypothetically.
Hypothetically.
For a friend.
Any purpose or benefit.
Any purpose or benefit?
Any purpose or benefit.
Yeah.
Any purpose or benefit,
like
quote,
said,
under the INA.
Like we said earlier, claiming to be a U.S. citizenship, the worst thing you can do in the eyes of the immigration law. It's up on the same level as literally murdering somebody. So.
Well, and they've talked about it in Congress a bunch of times. We've done all the research on this. They've brought it up, and it keeps getting brought up a little bit, whether or not they should allow it to be a waivable offense or to have a special kind of waiver. Nothing yet.
Yeah.
Nothing yet.
I mean, I'm even helping a client right now. She wanted to write.
Here it is. False for any purpose or benefit under the INA or any other federal or state law. So anything basically.
It would depend on
anything that's under a federal or state law.
If it was
right?
If it was a private employer and that's as far as it went, maybe not. But
I don't know. We'd have to really think about it.
We would have to know more details to know, basically, for that one. So yeah. We also look at things like did I talk about licenses and certifications and school factors? I only talk about student debt. But if you're if you're qualifying
student debt, we've used that.
Yeah.
Think about who backs your student loan, right? They don't want you to leave.
We've used both someone who had a child who had learning disabilities, and then that fact, and we also used the opposite, somebody who was so gifted that they were in special classes, or gifted in sport.
That she was a very gifted person, and there was going to be a major opportunity they were going to miss. We put that in there. That's what it was. She was at like an 18-year-old education level, and she was 12. We're talking like 8-9 years ago on these things, so details are a little fuzzy.
Yeah, but essentially the fact of the matter is that there isn't a right or wrong. There isn't one factor, one magic factor, one negative factor. It's really so fact specific that the first thing that we do when the client comes to us with the waiver is we have to go through and ask these questions because it's a balancing act. The government is going to look at everything, and they're not going to look at anything if you don't tell them. Anything positive if you don't tell them. I guarantee you they'll find the negatives, but you want to lay everything out. And if you do have a negative, you want to explain it in your statement. There are things that are understandable that will be excused or forgiven that don't amount to an inadmissibility, like little lies here or there, like they doubted your previous marriage was real, but you're saying it was, and you can explain what happened. We had that right now. We have a client who filed for his fiance. She was approved. She's back. She's in Ecuador right now. And then she went to the visa interview and they denied it. And they said she had fraud and misrepresentation because she had a previous marriage and she tried to get an immigrant visa and they denied it. And we had to file the waiver and explain what happened in that marriage. Why did she, they ended up not.
It wasn't a fake marriage. It was a bad marriage.
It was a bad marriage. And we see that a lot. And
yeah, not a lot. I mean, a lot of them.
Oh, we see a lot of bad marriages.
Fake marriage.
We do divorce.
Nothing we can do about them. Yeah.
Right. But just because the marriage didn't work out, it doesn't mean it can't be explained. And again, as I said at the very beginning, what's the number one most important piece of evidence here is going to be your own statement. And that's where you're not just explaining the good things, but you're also explaining any bad thing because you got to be out in front of it. You can't wait for immigration to come and ask you, well, didn't you commit fraud or what was up with this arrest? If you're upfront with them, you have your best chance. But if you try to hide something, it's going to really hurt you in the long run. It's happened. I remember the client I was in the green card interview with, who we didn't know he entered was the fake visa previously. And
what's a Quill-on-ton entry? What is this? What is this? I heard this before.
Quill-on-ton entry? I don't know.
Matter of Quill-on-ton. That's the BIA case. That case. Oh, yeah. So what is this about? Hold on.
You mean a wave through?
The hell's a wave through? Who does that?
Oh, right. Yeah, this is the person who's waved through.
Right.
So, with the wave through.
A wave through is not an entry with admission and
yeah,
inspection. It's just not.
The problem is you need.
I don't know why they waved you through. I don't
I'm
understand
surprised
that.
they waved you through.
That doesn't happen now. I can't imagine that happening now.
I don't.
What is? I wish the person could talk to us and we could ask. It's a kind of an amazing question. They just let you in, basically. You just show up and they let you in.
They take your information. I mean, maybe,
no visa, no passport. Just
oh,
popped you in the country.
1999. That's why. That did happen back then. Well, we'd order a FOIA and see if there's any proof.
I think I was in college, high school.
I have this situation
well,
with someone in removal.
The time you would be here, I would imagine the time you would be here would still be unlawful presence time. So.
Right, but.
You know what I mean?
Yeah, but if you have the.
Was there ever any other petitions filed for you?
Well, you know what we've done before.
I'm wondering about 245I. That's what I'm asking. Was there anything else filed for you back before April 30, 2001?
Your parents bringing you.
Because sometimes 245I was an amazing opportunity for people who had petitions filed for them, bona fide petitions, approvable when filed petitions, on or before April 30, 2001, because then they could actually adjust status.
I want to just say something about the wave through real quick. We can order your FOIA, and there might be something in there that indicates that you are admitted. If not, the only possibility is that if whoever you were with.
Yeah, no, Quinton Lon says they've not been admitted. It's exactly what we thought.
Yeah, we have situations where we've had affidavits from people that were with a person.
And we had a Canadian.
Yeah, with Canadians, they usually accept.
But they have a visa waiver. That's the difference.
Yeah, I don't know if Mexican.
The Quinton entry cases were able to apply. Hold on a minute. But not anymore.
Yeah, and
I think he's talking about it's 245. That's what it is.
There's another question.
It's like a 245I settlement case, probably.
There's another question. If your parents bring you back after deportation.
Oh, you know what it is?
What?
It's like a settlement kind of a thing. So, immigration officers shouldn't be empowered to choose who to to inspect and admit? That's an interesting thing. You know, it's a very interesting question, but if they're not doing it, they're not doing it. But I understand if you do get waved through, it's not your fault you weren't admitted or inspected. You know, you're here. You went up to the guy, he let you in, and you know, okay, I'm here. But
Well, that's why
I mean, that's
an immigration.
it
You might have a
stinks they
better
don't let
chance-
you do it anymore.
You might have a better chance actually with an immigration judge if you have the.
No, there's probably a thing. If they're saying they don't do it anymore, they probably.
No, if you have someone that can attest to you, I mean, it's not going to be easy. But there was another question we missed. Would parents bringing you back after deportation at the age of 8 be forgiven? There's a waiver.
Hold on, wait.
What?
It depends on how you were brought back.
That's true. How long you're out of the country.
Of course, if you were allowed back,
It also,
they let you in.
it also
If
depends.
they brought you back, what do you mean brought back? Like illegally brought back or legally brought back, but despite the fact that there was a previous removal order?
And was it because of an illegal
That's the question.
entry to begin with, and then a second illegal entry? That's a.
And was it one of these expedited removals?
That sounds like a FOIA would be needed to see what happened.
We just need to know more facts on
Yeah.
that case.
Yeah.
She needs to email us a story, a quick breakdown with some dates, please. Like a little timeline. All these things, the best way to send us a question is like a timeline.
Yeah, because it's complicated, and we're gonna have to explain every little
Super
thing.
complicated. I was talking to Amanda about this before, saying that ultimately we wouldn't really be able to give any real good answers because there's so many little factors that we can't talk about with people that are critical.
Yeah, these are some of our longest initial consultations.
Can you imagine this? I can't even imagine this. A non-citizen waved through a port of entry by an immigration inspector who asks the non-citizen no questions.
Well, not anymore. That would never happen.
I'm reading the thing. I'm just shocked that they did this.
Have you gone to Canada?
Yes, of course. They check your passport.
Well, Jessica, we'd have to review your FOIA to see what went on. Because I was saying earlier, you might think you were deported, but you could have just been refused admission or had an expedited removal as opposed
She
to a
probably
regular
knows her case
removal.
better than anybody in the world.
What?
She probably knows her case real good.
No, I'm sure she does.
She already has her FOIA? Yeah.
Right, I'm sure she does. But I'm just saying
And a
that
non-citizen gains entry in the United States at port of entry.
there are little things that can make a huge difference. So we would definitely need to review it. Yeah.
Basically, it's not
back
good.
in the day, they did wave people through. That was before 9/11 and stuff.
No, well, yeah. I'm sorry, yeah. I can't believe it's been that long since the 90s. Wow. 20 years.
Yeah.
Wow.
I know we've had a client who he came on a plane though. That was the difference. We were able to show the plane tickets at least. That's why it gets tricky. But
Were these,
again,
when they did that, did they ask you about asylum or something? I mean, how do they just go about letting people in
back then they just did
without
it.
passport?
I remember.
Did they really?
Yeah, I've gone to Canada that way.
Not Canada.
No,
I'm not
I
talking
know,
about Canada.
it's different.
I don't care about Canada.
But
I'm talking about, were they just letting people across the southern border, like, without any...
yeah,
Anything.
Yeah, they used to do that. But maybe
Trump would
you'll
be
be lucky
furious.
and there'll be something. Otherwise, it's tough, unfortunately.
We don't hear about that. Most of our clients also are not from the southern border, remember, because we're in New York.
Yeah, we have you can't fly in.
Most of our
without-
clients go through airports or boats. A lot through boats, Miami, people come like that. They just ask you what you're doing in Juarez and they let you in.
Wow.
I was reading a very interesting book talking about more like the 1800s at the Mexican-American border, and the U.S. and Mexicans were fantastic business partners with one another, and it seemed like the real problem started happening when the Chinese were coming in, and it was like they needed to limit that border. And that's what created the real issues in the southern border and created major problems between Texas and, Mexico, that whole area back and forth. And it's a fascinating history. So now due to lack of credibility.
Lack of credibility.
Lack of credibility and evidence. Is that, do you mean like unable to prove the marriage is real? Is that what that is? Or lack of credibility about your admission?
You got a border crossing card?
Oh, that's
That's different.
Interesting.
if that's what it is.
If that was,
If you had a
yeah,
border,
that was for people who work on one side of the border and live on the other side, right?
then there should be some
That's the
record.
kind of thing I was reading about.
Then there should be a record.
Yeah. But it's a wave through, it's clear. I mean, it's not an admission inspection, it's the same thing.
But if he has the card that was valid at the time and he has
No, I'm reading this. This is something if we practiced 15 years ago, if you were practicing back in like 2000, you'd know all about it. Yeah.
it should be in your FOIA, a copy of that card. So I-130 was approved. So is it
Hold on a minute.
credibility with
Hold
the
on a
background?
minute. Hold on. Just give me a second, Amanda.
Yeah,
I think I used to deal with these things.
it's much less common now.
No, yeah, hold on.
Yeah, 2 years is nothing for immigration these days, unfortunately. What are you looking at?
I'm reading a summary of this law and the history of it real quick, and it's really interesting. But because ultimately, if you're waived through, you present yourself and they admit you.
Right.
The biggest problem we have, I've had people come and say this, but the things that we've had where you can't prove it, and that's what happens in court. Exactly. It's only best to be
Right.
tested.
That's why
weird.
I'm saying even if you had at least another person who could attest to your entry, and then you get the you get the FOIA and you show the boarding crossing card.
It's because they have to go back because it's all silly semantics in my mind. But the reason is because if you're not admitted and inspected, then you don't have a status to adjust from. It's that simple. And I want everyone to think about this very simply. I was trying to think of a good analogy. In my office, I have a painting, a very big painting picture. I haven't been there in a while, so I don't know. But it's a bridge going across the water, and it's a wood slat bridge on vine ropes across a very large river in Kenya.
Very pretty.
And we're talking 12-foot by 8-foot painting. This is big. Now, in order to get across a wooden slat bridge with vine ropes, you need to have wooden slats. And if you don't have a wooden slat to stand on, then you're going to fall down and you're going to go in the river and die, and alligators are going to eat you. So when you have immigration status, you have to always maintain a status. Think about it like the wooden slat. So the minute you don't have a status, then you don't have a status to adjust from. So ultimately, the fact of the matter is, whenever you have that gap, whenever you don't have the wood, whenever you don't have a status, you're not going to be able to adjust. And if you come in the country without any wood, meaning you don't have any status, you're definitely not crossing the bridge. That's why they make you go out, because you need to go out of the country to come back in with some status, with an inspection admission. You have to have some wood to have a bridge.
And just to clarify from what Anthony said, they don't send you back to your country to pick up your green card.
No, you go.
That's not exactly how it works. Just so I don't want to get people confused. That this is somebody who did enter illegally. They need to leave so they can come back and be inspected and admitted.
To apply.
But they need a waiver, and they're going to get denied if they don't have an approved waiver, and that's why they're getting denied. But people who enter like with a B2 visa and then adjust their status, if they have no inadmissibilities, they don't have to leave. They get their green card.
Because they presented for admission inspection.
Right. The whole idea is like
so as long as they maintain a status.
You presented yourself at the border, immigration checked your name out, who you are, they know who you are, and they let you in.
Okay, come on it.
Right. And it's tough with the wave throughs because back then they did do that, and they have to believe you. And
if he's in the back seat of the car, he's not presenting himself for admission inspection. It's that simple. Case closed.
Right, but it wasn't his fault. I mean, technically,
it's not about fault.
No,
he just didn't present himself for admission inspection. That's why we said that at the very first part of this thing. Sucks, but it's what it is. A lot of problems happen at the Canadian-New York border up near Toronto and towards Montreal there, because for years they weren't checking people in. They didn't care. We had a client just recently, remember, Amanda, going across, and I made her go into the building to get a stamp.
Yeah.
Because I didn't trust that they were going to put it in the computer.
They were just going to.
And it took like 2-3 hours. They were like, we don't need to stamp you. You're fine. You're Canadian. But we needed her stamped because I needed her admission.
Yep.
And it was ridiculous. And she had to get out of the car and park and go. But then the officer was like, you're very smart to do this. Okay.
Well, your friend from Trinidad,
Got some smuggler friends.
well, either your friend was deported, had other grounds of inadmissibility. But yeah, if your friend overstayed for more than a year, the second that your friend left triggered the 10-year bar. You can apply for a waiver. You might have to wait certain bars you have to wait the 10 years. Some you can apply earlier, but it sounds like the person was deported, so they would need it
That's just if they're deported.
Not just a 601 waiver, but something called an I-212 to basically kind of forgive the removal order. So that's a whole extra part of the process. That's not that easy. But if we actually had a client who was deported, waited 10 years, and this is a heartbreaker. His wife filed, he had to separate from his wife and kids for 10 years. Finally was eligible again. She filed for him. It got approved. And he was waiting for his visa interview. And he's from Nigeria. And then they announced a travel ban from Nigeria. And he's still waiting to come in. So, but he waited the 10 years. He could have tried to apply earlier, but he would have needed to have that 212 waiver, which are not easy to get approved. So by waiting the 10 years, he was able to just do the regular process, but unfortunately, the timing. Aaron is suffering a lag again. He's going to stay quiet. You mentioned spouse or parents requesting someone for your citizenship. What about kids requesting a parent? My son will be 18. The son has to be 21 to file for you. So when your son turns 21, the day he turns 21, he can file for you. She was living here for 25 years, and his son said he filed for her. I'm sorry. So
That's not a bad idea.
Okay, that's why. Oh, that's why. It was a family preference category. Okay, so to adjust your status in the U.S. without leaving, it's not everybody who can do it. The family member who filed for you has to be an immediate relative. So that's a spouse or a parent, or if you're a child under the age, under 18 or 21, it's a parent.
21.
21. So either.
Wait, what's your question?
What?
I'm hearing an echo. Everything's on an echo.
All right. But basically,
I'm gonna log out.
If you're
and
married,
then come back.
If you're an adult child, for example, and your parent files for you, then if you overstayed your B2, you do have to leave to get your green card and come back, and you need a waiver. So it's not everyone. I apologize if that was confusing earlier. Aaron, let me know when you come back. We'll try to get you back in here. So we're gonna start wrapping up soon. It's already 10:03. If anyone has any more questions in the meantime, hoping we get Aaron back before we sign off. But if you have any other questions in the meantime, please do not hesitate to ask. I'm gonna try adding him one more time. Okay, here he comes. Here comes Aaron. He's connecting. There he is. All right. Okay. But we'll probably start wrapping up in a couple of minutes. We didn't get into all of the criminal grounds, all the exceptions to the criminal grounds, like the petty offense exception, the conviction for marijuana possession under 30 grams.
Yeah, if it's
don't get
crimes involving moral turpitude versus ag fells, all sorts of stuff.
That's for.
We'll have to do another one. Those are fun.
Yeah, that's where it gets real interesting.
You have good stories for that.
Yes, yeah, Anthony, I apologize. I didn't realize it was an immediate relative. That's why. So that's actually a point I wanted to make that I forgot about. If you're married to a permanent resident and you overstay, or you have some type of you working without authorization, anything like that, or your student and stops to go to school, one of those types of violations, it's a good idea to talk to an immigration lawyer. It might make more sense for you to wait for your spouse to become a U.S. citizen before they file for you. It's most of the time that's what we're going to say, but there are situations where if your spouse committed a crime or something, they might not be able to apply for citizenship. So if you're in that situation where you have a spouse who's a permanent resident, then before you file, check with an immigration attorney to see if you should wait till they become a citizen or not. That we've had that situation. That's a pretty common situation as well.
Inherent with the nature of this kind of question, with all of these inadmissibilities and everything, is sometimes we have to consider what's the least worst alternative. Mm-hmm. We really do, because we have, sometimes you have to really think about reality and life planning and family planning and stuff like that. So sometimes you have to say, people will say, look, I'm going to leave the country, I can't do this. And then the spouse like, don't. And then we say, look, let's try the waiver. If it works, fantastic, right? If not, there's nothing you can do, really. I mean, you've tried everything. But sometimes it's not perfect.
Yeah, and what we do with the waivers when clients come to us is that we go, like I said, initial consultation, we're going to go through these factors. And if there's nothing there, we're going to tell you not to waste your money and time. We're going to be
we're not interested.
It's going to make my life so hard trying to make something work that's not there. Not everybody gets waivers approved. You have to have the extreme hardship. You do. And
it also depends on which officer happens to get your decision and make a positive or negative determination.
Just because it was denied, it doesn't mean it can't get approved if it wasn't done the right way the first time. But if you come to us and, you have too many negatives to overcome and not many positives, we'll be honest with you, because it's just not worth your time. And we want our clients to get approved. We want them to be happy. And, we've been doing this for a long time now. We've done a lot of these. We're very successful at these. So we know, we have a pretty good feeling when things are going to work out and when they're not. But it all, you have to work with us. You have to get the evidence we tell you to get. If you don't, we can't do anything about it. We can't make up the evidence. So it's teamwork. I also want to say we didn't get to J1 waivers. That will be another time. If you have any specific questions.
There's not going to be any J1s anymore. It doesn't matter.
Oh, come on. It's temporary. Come on.
It's a joke. Also, the waiver people have already been here a few years. I know. It's always years.
Yeah, no, there's J1s who are here now, because if you are here on a J1, you might be subject to a requirement.
Think about closed because of not having income during Corona, and then he pulls J1 visas, so now people can't get au pairs.
Oh, yeah.
What the heck are they thinking?
Well, we're not here to be political. We're here just to go over it.
It's not politics. It's money.
And extreme hardship waivers. But we hope that you found this helpful.
I have a friend who's a lawyer in town. You can't get someone to watch his kids. I'm sorry.
It's okay. We've all been going through a lot lately with everything going on. If we did not answer your question today and you still have questions, please feel free to reach out to us. We are definitely here for hire. If you've missed any of our previous lives, they're all on our Facebook page. You should check them out. We covered all different topics.
We're going to figure this out, the tech.
We'll be back in a few weeks. Yeah, we'll be back.
Send us a request for topics if you got one.
Yeah, if you have send us requests. Follow us on Facebook so that you don't miss any of our lives. And again, any questions, we're here for you, and we hope that you found this helpful. Thank you all for watching, and we'll see you in a couple of weeks.